hopefully we'll get a feed here in just a minute. Okay, we're now live on Facebook. And ladies and gentlemen, first let me introduce a couple of people who are helping us with this. We have Elizabeth Tanker. Beth Tankard is a co-host who will help us managing this meeting. She is a City Council aide. And we also have Senior Council Communications Officer Megan Boyd, who is assisting us. So they will be keeping track of things here, making sure that everything operates properly, and we will proceed with this town hall. This is a Zoom webinar town hall, and it is a town hall with a webinar mainly because we wanted to have some control over how the judges are presented to you and how you may interact with them. As you probably many of you understand, judges are in a sensitive situation in which they cannot necessarily discuss a particular case or perhaps a case on appeal or maybe some particular issue of law, although they may wish to if they feel comfortable with that. For this reason, you are not able to speak to them directly. You may enter into the question and answer portion of this webinar a question, and we will probably be screening those questions. I'm sure that most of them will be appropriate, and we will be conveying your questions to the judges or to Sherry Harville as we deem appropriate. We will not be looking at the chat, at least for you who participate. And Megan, I did not disable the chat, so if you could go ahead and do that, I appreciate that. So we are going to be recorded and live on Facebook, and that's what should be going out right now. That's one thing I wanted you to know, as well as the fact that your questions will be put into the question box, and we will either answer them live or they perhaps you might be texted an answer. The last thing that I want to do is share with you one of the City Council's web pages. What we are experiencing in the fact that we have one municipal court judge position open is that a number of potential applicants have sent us a resume. This is probably a result of or a function of some of the websites that allow you to apply for jobs and send your resume. However, the requirement is that you fill out a municipal court judge application, which is on the City Council's website. So let me briefly share my screen with you, and it'll just take me just a second for me to bring that up. And I want to show you the Tulsa City Council's website. And this is where you can download the Municipal Court Judge's application. So this is the start page, the splash page for our City Council website. And if you scroll down like I'm doing right now, just a short distance, and you will see an area in here where it has a link to the Municipal Court Judge application. And if you click on Read More, then it will take you to this page. And if you scroll down after you see all the requirements for a municipal court judge or for you to apply for a municipal court judge position, you will see this area right here that says Here. If you click here, you will see the application. Now, the application does ask you to attach your resume, as well as answer approximately 50 questions, most of it which can be answered yes or no. If it's no, typically you don't have to do anything else but just check the box. But I did want to share that with you because we will only consider applications that are properly filled out and complete with a resume attached, and there is, I believe, a writing sample or at least a cover letter that's required. So those are the main points I wanted to cover with you at the beginning of this. We are going to start with just some brief introductions, and then we will go through what is a typical day in front of a municipal court judge in Tulsa. And then at the end we'll have question and answers, as well as perhaps some common what our municipal court judges experience in their lives outside the court. Because if you are appointed to a municipal court judge position, it does affect your lifestyle and what you can or can't do. So let me begin by introducing myself very briefly. I am going to be moderating this town hall, and just my background, I can tell you that I've been with the city of Tulsa 30 plus years. I started out as a police officer in the 70s, passed the bar and became a lawyer, and then I went to the city attorney's office and spent 28 years there. I was a prosecutor, I was a deputy city prosecutor, and then ultimately at one time became a full prosecutor, city prosecutor there. I did do hold other positions in the city attorney's office, mainly dealing with zoning and personnel issues. For a brief period of time, I went to the city of Bixby and was city attorney there for 6 years. And then since then, I have, in the last couple of years, had the pleasure of serving the city of Tulsa as the city council administrator. In that role, I am facilitating the city council's appointment of municipal court judges, both full-time judges and associate judges. You have here Presiding Judge Mitch Mccune and Judge Gerald Hofmeister, who have already been reappointed for another 2-year term. But we have one judge who is not present. His name is David Shapiro, Judge David Shapiro, and he is asked not to be reappointed. I believe he wants to retire. So that's where we are right now. We're trying to facilitate the replacement of that open municipal court judge position. But in addition, the city council wanted us to hold this town hall, not only to give potential applicants some idea of what they may be getting into if they're appointed to a municipal court judge position full time, but we also wanted to make sure that citizens had an opportunity to kind of interact with the court when they don't typically have that opportunity, because the only time they see a judge is in court. So we wanted to give you a good feel for really what the municipal court is like, and give you just a sense of it. And that, so if you ever see a municipal court judge, you'll know exactly what they go through. And if you ever happen to appear in court, then maybe you'll have some better idea of how things go. With that, let me first introduce to you the court administrator. That is Sherry Harville, who is here. And Sherry, if you want to say a few words to let people know a little bit about you, please go ahead.
Yes, good evening. I have been with the city of Tulsa for 18 years. I spent 15 of those years as an administration manager overseeing personnel and budget. I'm actually pretty new to the court team, and I've only been a court administrator here for about 6 months. I am married with 3 daughters. I have 5 granddaughters and 1 grandson.
Thank you, Sherry. And let me next introduce to you Presiding Judge Mitchell Mccune.
Thank you, Mr. Bolden. My name is Mitchell Mccune. I'm currently the presiding judge at the City of Tulsa Municipal Court. I am a proud lifelong Tulsan. I'm a graduate of Tulsa Memorial High School. I've been married to my wonderful wife, Reagan, for approximately 20 years. She's been very supportive of my judicial career. I have 3 wonderful children that are all teenagers, and I look forward to the opportunity of working with a new judge. And I also want to thank Judge Shapiro for his 30 years of service to the city of Tulsa. And also thank the city council and the council administrator staff for providing this opportunity tonight.
Thank you, Judge. And now let me introduce to you Judge Gerald Hofmeister.
Thank you, Patrick. I want to first give thanks to everybody that chose to view this webinar. I'm grateful for the interest, and I'm a Tulsan by choice. I love the city of Tulsa. First came here in 1982, went to law school at TU in the 90s. This is my 19th year of service as a full-time municipal judge, and I'm grateful every day for that opportunity to work with people that come in and out of the court and in the community. Thank you to the City Council for this innovative webinar format. It's really great to look forward to hearing the questions that you might have for us. And of course, we're looking forward to presenting a day in the life of the court. Thank you again, and look forward to this process.
Thank you all. So that's your panel for today, and I'm your moderator. Next, let me share with you my screen briefly. And so here we have the initial slide, which you did not see as the judges and the court administrator introduced themselves. The next thing that I want to provide you is just an overview of how the court in Tulsa was created, its jurisdiction, and then I'll probably turn the majority of this over to the court administrator and the judges to tell you much more about how the court really operates. I can tell you that the city's municipal court has really been in existence since around 1909 or 1910, when it became a municipal corporation under the new state of Oklahoma. City of Tulsa existed in the 1800s as a town, but when it gained statehood, the City of Tulsa adopted a municipal charter. And in that municipal charter, it created the municipal court. That lasted for a long period of time. And I believe in the 1960s, there was a significant reform in the courts in Oklahoma. And at least at that time, I don't know if it was prior to that, but a lot of courts were renamed and jurisdiction was rearranged. And the Constitution of the state of Oklahoma provided that municipal courts would be created by the state legislature. And they specifically said that these cities and towns, their municipal courts, would be limited in jurisdiction to criminal and traffic proceedings that arise out of ordinance violations in their municipality. So with that, the municipal courts of record and not of record were created. And there are statutes that provide on how those courts would be created. And I'll give you briefly a distinction between those two kinds of courts. But the municipal criminal courts of record, like the City of Tulsa, which pre-existed in 2004, continued in existence as they did and existed in the 1960s. Then at that time, if you weren't created before that date, then you had to have your city council adopt a resolution for the creation of a municipal criminal court of record. Right now, there are only 2 municipal criminal courts of record, one in Oklahoma City and one here in Tulsa. One of the requirements that you become a municipal criminal court of record is that you have at least 65,000 inhabitants of your municipality. And we do have some that do meet that qualification, but have not elected to have a municipal court of record and have remained to have a municipal court not of record. Broken Arrow, Bixby, Sapulpa, Glenpool, all the surrounding communities here have courts not of record. What does that mean? Well, for a lot of people, it doesn't mean much. A municipal court not of record does not have as high an authority to impose penalties. They are limited to 60 days in jail and, in many cases, $200 fine. There are exceptions to that, which I won't go into, but that's the general power of a municipal court not of record. And also, on rare occasion, it is still legal for a municipal court not of record to have a judge who is not an attorney. So there are some of those in the state of Oklahoma, but I know from my experience with the Oklahoma Municipal Judges Association, there are only a few. Municipal courts not of record means that really what it says, there's no record of a court proceeding there. There's no court reporter. And because of that, the right of an appeal from a municipal court not of record is to the district court where a record can be made. And if an appeal is taken from there, it can go to another court, the Oklahoma Court of Criminal Appeals. In a court of record, of course, there is the opportunity for the parties, the plaintiff, the city, and the defendant to make a record that could be appealed directly to the Court of Criminal Appeals in the state of Oklahoma. So that's really the distinction, the major distinction, at least procedurally. The other distinction is, as I said, the penalty that the court not of record has. A court of record has the jurisdiction to impose a 6-month jail sentence, or as a general rule, a fine of up to $1,200, with the proviso that if there is a state law which imposes a lesser penalty, the municipal court in municipal courts of record cannot exceed the same penalty or the penalty that's established for the same offense under state law. There are exceptions to that maximum penalty, and that is in cases of prostitution, some pollution cases, and I believe perhaps DUIs. And that's perhaps another distinction. Municipal criminal courts of record can prosecute DUIs, driving under the influence, and municipal criminal courts not of record do not have that authority. That authority was taken away a couple of years ago, 2 or 3 years ago. So that's generally an overview of the creation of the courts in Oklahoma, particularly our court. The only thing I really would like to address is really the judges in our municipal criminal court of record. Generally, the qualifications for a municipal court judge in a court not of record, you must be a lawyer for at least 2 years. You must, in this case, be a resident of the city of Tulsa, and you must have been a resident of the county for at least 6 months. And some of those are imposed by state statute, and we do have some of the provisions that are established by our city ordinances. Our city ordinances provide that there may be up to 13 judges of our municipal court, 3 of which must be are full-time judges. The remaining number are associate judges. I may have not mentioned that, but I'm an associate judge too, although I have not been called upon to serve as a judge in the municipal court for at least a year. We also have other judges, associate judges that I believe are participating in this town hall. And so there are at least 4 others right now. It is possible for there to be as many as 10 associate judges and as few as, I believe, 7, or at least we had 7 before, I should say. We recently had the death of one associate judge, and we also have one judge who has asked not to be reappointed and is retiring. So right now we have 5 associate judges and 3 full-time municipal court judges. I believe that's all I have. I'm sorry, I'm going to stop sharing my screen here for a second. I don't see any questions. So let me then share my screen again. And let me introduce to you Sherry Harville, our court administrator, to just give you an overview of the municipal court caseload, staff, and generally how the court is administered.
Yes, just like you said, I'm going to give a brief overview. The main thing I want to present is that the judges and I were very citizen and service focused. As a step toward that effort, we have trained all staff recently in customer service, and we've also scheduled additional training workshops for April and May. We also implemented a new citizen survey, just came out this week, and we look forward to receiving feedback and making improvements based on those comments that we receive. We're engaged in configuring a new court management system, and that's going to automate many of our manual processes, and very much look forward to that happening. And we anticipate that going live toward the end of this year. And then just some basic kind of 101 of the court, how to find us. We're located in the Police Municipal Courts building at 600 Civic Center between Tulsa County and the Cox Business Center. We're open 8 to 5, Monday through Friday, and we have a cashier available 8 to 4:30, Monday through Friday. Additionally, we have allow individuals to come in and add on to an arraignment docket each day if they appear between 8 and 10 a.m. Then the number of defendants that we're seeing in the courtrooms themselves. In a typical year, the courtrooms have, each individual courtroom has 1 to 200 individuals scheduled to appear daily. After I reviewed the 2021 calendar from January through March 31st, we're getting about 96 average daily arraignments daily in each courtroom, which includes 25 add-ons. And then the rest of the day's dockets, we're seeing about 92 individuals in each courtroom. Our court staff is 34 personnel, which includes the 3 full-time judges. And then we also have 5 associate judges, as Mr. Bolden mentioned earlier. The other staff in the courthouse is 3 minute clerks, 3 bailiffs, 2 court reporters. We have 2 public defenders, 1 full-time and 1 part-time, 2 probation officers, 4 managers, a cost administrator. We have 6 personnel and records and 5 in our bonds area, an administrative assistant, a business analyst, and then 1 cashier, which is provided by finance each day. And that is our staff.
Thank you very much. I don't see any questions, and so let me again share my screen and introduce the next topic. And that is the daily court operations, and for this we will turn it over to the Judge Hofmeister and Judge Mccune to discuss arraignments, defendants' rights, services of information, entry of pleas, and generally how the day of the court begins. And I might add that an arraignment is probably the first time any citizen would have a contact with a judge. So I think it's really good for them to try and put people at ease as to how that arraignments go and what your rights are. So with that, I turn it over to you, Your Honors.
Thank you, Mr. Bolden. Essentially, when a citizen comes in to our court and have a court date, they'll come up, they'll enter in through the north side of the building. We have many COVID protocols in place. They'll encounter a court liaison staff member that Ms. Harville has created to help assist citizens coming into the court, helping guide them to where they need to be, what division, whether or not they need to add on their case to our docket. Then they will go through court security. And then we have some of our bailiffs out assisting other folks in the hallways to make sure they get into the various courtrooms and into the various areas they need to go to. When you enter a courtroom, you'll be assigned a division, division 1, 2, or 3. And that is basically based upon the numbers on your traffic citation. And then once you enter into a courtroom, you'll be advised of various formalities and procedures by the bailiffs. And then the judge will enter, and the judge will give a brief statement and then move forward with the arraignment. And for that portion, I'm going to let Judge Hofmeister, who's also our senior judge here at the courthouse, to go through that part of our morning.
Thank you, Judge Mccune. With this time of COVID that we've been in, the first thing I do when I come out in the courtroom is to greet everybody and thank them for wearing their masks. And sometimes folks are anxious. Obviously, those that are on the opposite side of the court from me have been compelled to be there. And I say that to them, you're compelled to be here. And we don't want anything bad to happen to you. We care about your health, and we want to preserve that. And then I began to simply set out options for the defendants. First of all, you should know that our courts do not require a plea of anything but not guilty at the very first arraignment date. I tell them, you should know that if you come to court today, you have the option of myself entering a plea for you. You could enter a plea of not guilty. You could enter a plea of not guilty. And if you do that, we will set your case into the future so you have plenty of time to consult with an attorney of your choosing and seek some legal advice. I also remind them if they can't afford an attorney, a court-appointed attorney could be provided to them through our public defender's office. And then I will highlight the fact that there can be consequences outside the courtroom besides the fines, costs, and potential jail time that they're facing here. There can be real-world consequences to other areas of their life, including employment, their immigration status, their ability to continue to legally drive. And I highlight those because judges cannot give legal advice, and we need to make sure that people realize that there can be those external consequences outside the courtroom. At that point, I'll mention that we have 3 dockets to call in the morning. We have an arraignment docket, a 9:30 conference docket, a 10:30 review docket. The 8:30 arraignment docket is specifically designed to inform the individual defendant of exactly what the city has accused them of doing. So individually, they'll approach socially distanced from the staff and other court personnel, and I'll tell them exactly what they're accused of doing. I'll inform them if there's a possibility that the offense could be a predicate to a felony. We have several of those in our court system. The most notable is driving under the influence of alcohol. On each offense, I'll describe the minimum maximum punishments and also let them know that if they choose to go ahead and enter a plea of either guilty or no contest today, that I'm not going to surprise them with jail time. If they do decide to go ahead and enter a plea of guilty or no contest, the most they will face is a recommended fine plus the court costs. Now, every defendant has a right to represent themselves. We try to minimize the amount of contact we have here with the court moving forward. If individuals tell me that they would like to represent themselves and speak to the prosecutor, of course, they could do that today or do it on the day that they appear. Certain offenses are so serious that I do enter a not guilty plea on the behalf of the defendant. DUIs, larcenies, assault and batteries, aggravated speeding, drag racing, things where or charges where there's a real potential of jail time being meted out. And sometimes the prosecutors will actually recommend jail time at the very initial arraignment. So you definitely need to have legal advice, the individual defendant does, and happy to facilitate that. Now, during the time of COVID, I've not been increasing the court costs for that initial setting. We recognize that the enormous cost of coming to court, missing work, the potential of hundreds, possibly even thousands of dollars that could be assessed daily is a burden on the community and on the individual. And we will work with folks to give them time to pay and conduct Rule 8 hearings if appropriate. And they're always appropriate, by the way, we do assess the individual's ability to pay the moment they enter a plea. Now, when you enter a plea in our court, because we do have predicate offenses, any charge that has potential of jail time, we require a record of plea. Also, the individual, if they talk to the prosecutor and are being placed on probation, we have rules and conditions formalized. And the one thing that we also do is serve each individual with a copy of an arrest information. There's two ways that you can come into the court to be charged. One is with a ticket issued to you and you appear in the courtroom. The second is when you get arrested and through the city prosecutor's office, an arrested information is prepared. The information is a way of communicating to the defendant exactly what they've been accused of doing. And we formally serve that in the courtroom to the defendant so they have in their hands when they leave exactly what the charge is. Sometimes people will absolutely they just want to enter a guilty plea or they want to enter a blind plea to a judge. We can allow that too, but we always advise them of the potential consequence of not knowing what's going to happen if you do enter a blind plea to a judge. Judge Mccune, do you want to refer to or talk about the conference docket at this point?
Let me jump in there. I think it might be something we've got later down on in this, unless you think it's pertinent, Judge.
The pretrial, yeah.
No. I don't know if you have anything else to add before I do have one question that we've received and one compliment to the court for making yourselves available. Tina Pina advises that you're very personable and you set people at ease. Let me go ahead and submit my the question, and that is from Carly Jamerson. Is there a reason why the Tulsa County identification badges are not honored in the municipal court?
I can address that if you don't mind. Ms. Jimerson and to the other folks out there, it was my position throughout the years that those cards should be honored. However, the doors that enter this building are the executive branch doors, and they run the property. So there was a decision made by a previous administration not to accept those cards. However, that is on my list to approach Ms. Harville about to reevaluate. But quite honestly, with the COVID and administrative orders and all the incredible, wonderful, various new things that Ms. Harville's brought in and the training and stuff, it has not made it to the top of the list. But that is on my list to discuss with Ms. Harville in the future.
Anything to add, Judge Hofmeister?
I do think there is a degree of respect that would go with honoring those badges and also facilitate movement in and out of the court. there are also maybe questions with the folks that manage the building, actually. I think some of that may be rooted in a decision to just ensure security in our building. Of course, we want the attorneys to be respected, and I can see how that could be perceived as disrespect to make folks go through the metal detector. When over at the county, they can just show the badge and come right on in. I did want to get back to talking about making people feel respected. The culture of this court in the arraignment through every step of the process is to allow people to be heard, to actually listen to the individuals that come into the courtroom. And so during the arraignment time that I mentioned earlier, sometimes folks will really want to share with you what occurred in the case that brought them here to court, the facts of the case. And I have to routinely say, I'm really interested in what you want to tell me, but as a judge, I cannot hear the facts of the case at the arraignment. But we'd be happy to set it on a future court date. Ultimately, if you want to have a non-jury trial for a matter, we can set that even today. And at that point, you'll have every opportunity to tell me exactly what happened from your perspective. I think people really have a stereotype sometimes of what municipal judges are like. And it's probably not a positive stereotype. I think the culture here has come to where we cut against that by honoring and respecting each individual. If you've seen them for the first time or the 100th time, which is not an exaggeration for some of our defendants, you still presume that they're innocent. You still refer to them or offer them every opportunity to be heard. And you know, I'm proud of how the court has evolved in that direction.
Thank you, Judge. I tell you, let me ask you this, both judges, this question. If I come into your courtroom and you ask me how I plead, and I believe I'm guilty, am I lying to the court if I say I'm not guilty or plead not guilty?
Judge Hofmeister, you can proceed with that. I apologize, ladies and gentlemen, for showing my phone, but that's part of it about being a judge. I just received an emergency phone call from jail, so I had to take that as I'm the jail liaison judge. So I apologize for that.
Often in the midst of an arraignment, we'll talk about how a not guilty plea is a procedural plea that allows the case to move forward. Definitely, a not guilty plea sets in motion the city's requirement of having to prove its case against each individual beyond a reasonable doubt and every element of that case. What I have started doing routinely, I think Judge Mccune does this as well, is just entering a not guilty plea on behalf of the defendant, giving them a future court date. We have many charges on the arraignment docket that I refer to as correctable matters. They're like a no insurance, expired tag, expired driver's license. And one option, we talked about options earlier, option number one, I'll enter a not guilty plea for you, set it on this future court date, give you time to get your license updated, your insurance put back in full force, and your tag updated. So during that period of time, you get to legally drive. And when you come back, the prosecutors have standing motions on certain cases to dismiss them on payment of court costs. The most hurtful charge, in my opinion, as far as taking away your license immediately, is a no insurance ticket. If you get a conviction for no insurance, it's an immediate suspension and an indefinite suspension. I refer to it to folks in the courtroom as a forever suspension, because that's what it is. It will remain in place. There's no time period where it'll fall off until you show that you have new insurance and pay at least $300 to get your license back. So if you are already in an economic hardship, that's a little bit like taking your economic car and driving it off a cliff. And so over the years, 19 years of doing this, I have seen literally generations of defendants who, they were young people when I saw them, now they have kids. The kids are teenagers. And that cycle of driving without a license continues. Much of it is rooted in economic hardship. And so we will work with folks and give them the new court date to come back. Many people take that opportunity. and actually help themselves move forward, being able to legally drive.
Thank you. And Judge McCune, do you have anything to add?
I just think it's important for folks to understand that we both, as judges, presume everyone's innocent. And most of the time, we both enter a plea of not guilty. That way, folks have the opportunity to do things that can qualify for programs and assistance and those sort of things. So I think it's important. One thing I say quite a lot in the courtroom is it's not my job title to trick anybody in jail or set anybody up for failure. My job is to advise the charges that they face and the maximum penalties, but it's also to give them all the information they need to have the best outcome for them, and to identify and to discuss with them all the different various programs that could save money, save their driver's license, those sort of things. So, and I think that's important for folks to understand. And I consider that part of the public service that we do. And Judge Hofmeister is very, very good at it, and I learned from him.
And building on that, at the arraignment time, Judge Mccune and I are both conscious of assessing individuals' needs for interpreters, the potential. We absolutely have to be able to communicate clearly with an individual defendant, and we will schedule a future court date if we do not have an interpreter available immediately. We are exploring possibilities of working with interpreting classes in the area through TCC as helping supply extra force multipliers to help us in the morning. We have, there are challenges there, but those challenges are why we're here and why we will work with folks. We absolutely will pay for the interpreter to come in. Some of the language groups that have recently emerged are Zomi, Marshallese, and Chukis. And one thing I love about this job is interacting with people in the courtroom and interacting with the variety of cultures that come through these doors. It's a great equalizer to the city. The wealthiest to the poorest come through. The newest to the oldest come through. And so everybody gets treated with respect. Everybody is given a pathway with options to proceed forward with whatever is best for them in their life circumstances.
Okay, I would like to ask one more question, and we've encountered that as judges at arraignment, and that is, it's not a time for a defendant to tell their story. If they start telling their side of the case, what's the danger to a defendant?
Well, as a court of record, theoretically, you could be making an admission on the record that you did exactly what you're accused of doing. There is an intermediary plea called a plea of no contest that folks opt for at some point. But if you just start talking about your case without sharing it with an attorney, you might lose defenses. You may have, again, inadvertently basically confess to doing what you're accused of doing without first consulting with an attorney. So it's a dangerous path.
Thank you. Anything to add, Judge McCune?
If there's too much of a discussion, you also set the judge in a position where they may have to recuse from the case and the case be transferred to a different division. Because you're discussing the facts of the case where that judge may actually be the trier of fact.
Right.
And one last element of that, Patrick, is if you have a crowded courtroom, others who want to simply come forward, enter a plea, and move on, you have to respect the time of everybody in the courtroom. At the same time, giving people a little bit of opportunity to vent is not a horrible thing. I think it actually builds a rapport between the judge and the defendant of trust and interest. You just can't let it go too long, and first warn them that they're on the record and to be careful. But then it allows other people to be heard as well.
Yeah, that's. I think it's an important point about judicial economy. And let me just. I'll get to you just a second, Judge McCune. I would just let people know that when I was a police officer in the 1970s, we had 3 municipal court judges full-time. We still have 3 municipal court judges almost 50 years later, it seems. So your caseload has not gotten any smaller, and everybody's time is very important for that. So with that, Judge McCune.
If I might briefly add something that's extremely important, I believe, to both Judge Hofmeister and myself. Everyone has a voice, and we want them to be heard. It's sometimes at that specific legal procedural posture that we can't hear those things. So I don't want it to seem like that we don't want to have people be able to have their say, have their voice, and be heard. It's just sometimes there's a procedural posture in place where that's not the right and appropriate time.
Thank you. Anything else before we move to the next topic? Then before we do move, we do have another question about the qualifications for being a municipal court judge, a full-time judge, and I can only answer that question that those are established by law, and there's no provision for waiver of that for those who don't meet perhaps the residency requirements. So with that, let me share my screen one more time, and we'll move to the next topic as soon as my computer will let me. Our next topic is going to be pre-trial conferences or plea bargaining. So, judges, I don't know who wants to take the lead on this one. I think Judge Hofmeister wanted to talk about this just a minute ago, and so I will turn it back over to you.
Sure. I probably defer to Judge Mccune on this, but I don't want to monopolize the time. But pretrial conferences are what we call the 930 conference docket. It's set in the future after the initial arraignment. Folks will come back either with or without an attorney representing them. If they're ready to represent themselves, they will step out into the hallway and find out what the city is recommending through the prosecutor's office as far as either a pathway to keep it off their record or potential fine only, but with a conviction, or fines, jail time, probation. In a moment, we're going to talk about different kinds of sentences, but the advantage of having an attorney with you when you come back to court is the attorney is like the intercessor, the person that stands between you and the prosecutor, and you're not speaking directly to the person that has filed the charge and is tasked with the job of prosecuting individuals in the city of Tulsa. Also, the public defender's office has a form of a pretrial conference or negotiation that occurs at the moment they meet the defendants in the holding area down here at our court. Many cases are resolved by agreement through plea at the initial arraignment, whether having an attorney present or not. And then some cases are continued by agreement to a future conference date so that certain things can be corrected with the individual's driver's license, insurance, etc. Really important that judges not hear those pretrial negotiations. Things are shared there that may or may not become evidence. We don't want to have that influence the way we view any particular defendant or set of facts. So those are always done away from the hearing of a judge, out of earshot. And so that's what I wanted to add. Judge Mccune?
Thank you, Judge Hofmeister. I think it's important, at least in general, to speak that the plea bargaining and plea trial conference timeframe, that's how about 91% of all the cases generally in a criminal court is settled. It is not a right, it is a privilege. And And so when the communications are conducted, if there's not a resolution, those communications are privileged and can't be used against the defendant. So it is a great way to come in and try to get all the options, multiple options on how to possibly resolve your case. But those are privileged communications and can't be used against the defendant. If it doesn't get resolved that day, then sometimes there's a pass for additional evidence gathering and information that both the city or the defendant can do, and it could be reset for another conference setting. Or if it's not resolved, then obviously when the judges enter a plea of not guilty on behalf of the defendant, all their trial rights and defenses are preserved, and they can move forward to a non-jury trial or jury trial should they believe that's in their best interest.
And then ultimately, if there's a breakdown in negotiations, there's a pathway through what's called a blind plea to the judge. Judge Mccune and I are both consistent about this in requiring a pre-sentence investigation for every defendant that enters a blind plea. I explained that I really want to know who I'm sentencing, what their what the history is, to see if they're appropriate for deferred sentence, or that a conviction is the most appropriate path. For years down here, we had very few blind pleas, but over the span of my time here, they have increased, not significantly, but we have more than initially.
Well, if there's nothing else to add there, I would note that there's some judicial slang that we use, and that's a blind plea. And I know there's other slang out there. I've heard of peekaboo pleas, and I won't get into that. But a blind plea, unless the judges want to add something else, is one that's done without the benefit of a recommendation from the prosecutor, and so you rely on a pre-sentence investigation. Is that a fair statement, gentlemen?
Correct.
Yes, sir.
Okay. If there's nothing else on that, then I think that let me share my screen again and move on to the next topic, which is somewhat related, and that is Rule 8 hearings. The Oklahoma Court of Criminal Appeals has a Rule 8. That's often, it's not slang, but it certainly is something that is a short reference to a requirement of our criminal courts, not only district courts but are also municipal courts, all municipal courts, whether they're of record or not. So, gentlemen, could you please explain what a Rule 8 hearing is?
Yeah, I'll it's hard to follow Judge Hofmeister. He's so good, but I'll try. All right. Typically, when a defendant is assessed fines and costs in the courtroom, we immediately do what I call as an in-courtroom Rule 8. I'll ask the defendant if they can pay their fines and costs today. If they cannot, can they make a partial payment? I'll ask things of, are they currently working? Are they receiving income? Are you working full-time or part-time? And we'll make an assessment. And that assessment under Rule 8 is to determine whether somebody's ability to pay, whether they're indigent or not. If some folks may not have the ability to pay, but they're physically capable of doing an alternative for time to pay or to pay their fines and costs, and that's community service in lieu of time to pay. And that's broken up into two different areas. One where you do work for the city of Tulsa, and sometimes you'll do work for a nonprofit organization, and you get $10 an hour for every hour you work. There are some folks who are both indigent and have physical disabilities and such. So when you conduct this hearing, you're trying to determine if somebody has the ability to pay or has the ability to do community service. And we do those quickly in court, but we also have an avenue where we do more of a formal review where we will actually set timeframes at 2:00 in the afternoon. A formal motion will be filed and an in-depth review of financial records, medical records, and those sort of things are conducted. It is something we take pride in, that we are very, try to be very proactive with not setting people up for failure. That's important, and that we work with folks, whether it's time to pay, whether it's work hours. We do understand with COVID and the pandemic, there's a lot of folks struggling and hurting out there. So we try to come up with alternative programs with working with them on payment, working with them on community service. And there are some folks that I have, it's heartbreaking, but they're in a position where they can either pay their fines and costs or conduct any community service. And on those under Rule 8, those fines and costs are suspended completely, and then they are free to leave and their case is closed. So it's a very important review step. We do like I said, we do an immediate Rule 8. I believe I can speak for Judge Hofmeister. He does immediate Rule 8 in the courtroom as well as I do. And then we work with the defendant to try to make sure that they're agreeable with everything, and that we're not setting them up for failure. And then we also, like I said, have the ability to conduct a full-blown Rule 8 hearing, and that must follow the more formal guidelines presented in the Rule 8 of the Oklahoma Court of Criminal Appeals rules. Judge Hofmeister, you'd like to add something, sir?
Just to say that has been the culture of the court as long as I've been down here, to inquire, give people options of either having time to pay, work hours, and then more and more the Rule 8 formal hearings have been set, and those are a valuable way for people to really present their case as to why they cannot pay. And if it's due to disability or poverty and there's no possibility of that changing moving forward, the fines and costs are suspended. And so we are really sensitive to the times that we're living in right now, especially with COVID. When young people come in and they don't have a job, but they're willing to work, I say, well, it's like you're laser focusing on taking out your fines and costs with this $10 an hour job. If you want to think of it that way, every hour you work, you get $10 suspended. And there's usually a really positive response. I like to point out that I thank them actually for their service to our community by beautifying the city, making it a better place to live, and reframe it as a positive way of resolving their fines and costs instead of a negative. And sometimes you have to get through the fines and costs to get your license back and reinstated. It's a quicker way actually of closing out your fines and costs than, like, say, a 6-month time pay order. And folks usually are very receptive to that.
Thank you. I think that one of the common reactions to someone who receives a fine or some sort of penalty in court and perhaps gets time to pay, and all of a sudden they can't pay, they haven't paid a dime. I think the natural reaction is, oh no, I'm going to be put in jail. So what advice would you give to someone who's a defendant? And Sherry, I don't know if, I believe the court has maybe some personnel to help people with making payments. So maybe this is an opportunity to add something here. So I can't pay my fine. What do I do? I don't want to go to court. I don't want to go to jail.
We have a cost administrator at the front entrance, 8 a.m. to 10 a.m. every day, Monday through Friday. So if part of the screening process is just that, try to avoid them having to come in and add on to a court docket or to see a judge. So she has authority through an administrative order from Judge Mccune to go over their situation with them and give them up to 90 days extension to make a payment. And they can come back and do it a second time as well. So it's very customer focused. The key is for them to come in and communicate that information. And then if there's been no payments over that 90 days, she may send them into the judge if they need additional Rule 8 hearing.
And I think Judge Mccune has often said that to defendants, it doesn't hurt you to come to court. Don't be afraid to come to court. It's the first step. It's engaging with the judge and with the prosecutor that ultimately could work out to your benefit. It's when people are afraid to come to court and don't come to court that warrants get issued and it can get much worse. Fortunately, I think our courts are welcoming of individuals. If they realize that, the word spreads to their friends, neighbors, and family members. And I think, I'm 99% sure that people that have gone through the system feel like they were heard and that they were given opportunity to understand how to make the payments, where to make them, working with Sherry's team as well. And it's very positive in that regard.
If I might, Pat, I actually say this in court quite a bit to folks who show up. Please go tell anybody that's a friend or family that has tickets that's scared about coming down here to come down. Just show up. If you just show up, a majority of the time, it gets a lot better than worse. We have options to help you keep things off your driving record, save your license from being suspended. Some people save hundreds, if not thousands of dollars. We have access to assist folks in getting licenses, and working with people. We have people we communicate with DPS to help them in that process. We have information to help them with licensing and tag issues. We have access to social services that Judge Hofmeister has been spearheading for years. We have all these things that we can do once you get down here that we can't do if you don't show up. And, it just gets better, not worse, if you show up. And I think that's a key thing that we're trying to get out. I know Ms. Harville's doing an incredible job of trying to communicate that out for the court. But that is something that is and I think there's some lawyers and associate judges that are watching this that would agree with me that that's one of the key issues. Just show up. Don't be afraid. Come down. We can help you. We can't help you if you have a warrant and you don't show up.
Excellent. I do have a question here, and I'll just read it from Michael Nesser. How does the court handle claims of disability where there hasn't been a Social Security, workers' comp, or other prior determination? How much evidence is required when a party may not be able to afford to be evaluated by an expert?
I'll address that. Let's say that the disability claim is pending, or they're fit to be evaluated. They have doctors' reports and other things they might want to present regarding disability. We will continue cases, get 6 months to pay, come back, bring with you whatever the doctor has given you. We can have a confidential hearing about it. They can represent themselves or have an attorney represent them. The Rule 8 hearings are conducted under oath and with a court reporter. That's a requirement of our Oklahoma Court of Criminal Appeals. And yet, if there are confidential doctor's reports and things like that, those don't become part of the official record. They're referenced, and they're taken into consideration, but they're not in any way included in our court records. And then, we work with people. This court has always had this culture of giving people opportunities to be responsible, and also if there needs to be mercy or relief due to disability or poverty, that we're ready to do that when appropriate, and don't flinch from doing it at all. So I don't know if that helped. Judge Mccune, you might want to add as well.
That's well said. But to the specific evidence portion of it, look, medical records are expensive too. Some people have a difficulty paying for those. So I tell folks quite a bit, don't bring me the telephone book version for any of us older folks. Bring me a couple of sheets of paper, and we'll look at it and we'll sit and talk. There are times when there are people who are diagnosed with stage 4 cancer and they haven't got a disability yet. And there are times when people have had catastrophic injuries on the workplace, and they haven't had a chance to get their disability. So we look at those documents. We talk with the defendant, and those are pretty resolved fairly quickly. But every case, want to be careful about saying this, every case is differently, and we can't guarantee any outcome of any case or specific fact scenario. But many times people will have the documentation. We don't, I guess the best said is, I don't rely on the U.S. government's determination of disability when I make a ruling on Rule 8. I rely on the defendant and their position, and that's what I take into account. It is part of the evidence if someone is determined disabled by the U.S. government, and that's important, I get it. But there are people who are disabled who are not receiving disability, and that also needs to be mentioned.
Well said.
Thank you. I have no further questions, so if there's nothing else to add, then let me share my screen one more time, and we'll go to our next topic. So the next topic is review and hearing docket. If you don't know, we're trying to go really in sequence of the number of dockets that our municipal court judges handle every day. So this is pretty much daily court operations. So this is a review of suspended, deferred, and continued sentences. I particularly like the distinction between a continued sentence and a deferred sentence. I don't think a lot of people understand that. And applications to accelerate. Somebody's pressing on the accelerator here. Sentencing and revoked suspended sentences. So who's going to take this one?
I'll start. Judge Hofmeister, you finish?
Sure.
All right. So, so you've come into your 8:30 arraignment. You've been advised of your charges that you face, the minimum maximum penalties that you face. You've entered you've gone to your conference date. You have agreed to a plea agreement with the prosecutor's office. You've entered into a plea agreement, and you've placed your plea of guilty or no contest in the record. And one of the manyest things you can have is be placed on a deferred sentence or a continued sentence, which is a type of sentence that would keep the conviction off your record. Those can be anywhere between typically 30 days to 6 month deferred or continued sentence, where if you stay out of trouble, you abide by the rules and conditions of probation, you complete any requirements under the rules and conditions of probation, that when you come back on a review date, your case could be dismissed on costs and probation fees. The difference between a continued sentence and deferred sentence, and they're quite frankly under the law treated similar in most circumstances, is that a deferred sentence, you can pay an additional $100 administrative fee, or obviously you can convert that into community service or work hours if you can't pay it. But for an additional $100 administrative fee, that matter would be dismissed and expunged off your court record as if it never happened. And that can be very important for some folks who have professional licensing, have business licenses, and those sort of things, in order that they don't have any long-term ramifications with their business or profession. A suspended sentence, on the other hand, is a sentence to where there is a conviction, and then you have been sentenced to jail. And the court will suspend that jail sentence on your good behavior and you completing the various requirements under the rules and conditions of probation. If you violate your rules and conditions of probation in a continued sentence or deferred sentence, an application to accelerate would be signed and filed with the court by the City of Tulsa Prosecutor's Office, alleging what provisions of your rules and conditions of probation that you violated. If you're under a suspended sentence, an application to revoke your suspended sentence would be signed and filed by the prosecutors, alleging that you violated your rules and conditions of probation. When you come back for your review date, you'd be served a copy of that application. And at that particular time, you have a right to enter a plea of not guilty, guilty, or no contest to the applications. If you plead guilty, many times there is a workout agreement with the prosecutors, what I call kind of a second plea agreement, where the prosecutors come in and they work out a deal with the defendant. That could be a couple things. They could extend the probation period in order that they can continue with their deferred sentence, or continue with their continued sentence and still get relief of the dismissal and or the expungement. Or they'll get additional time to complete their rules, conditions of their suspended sentence in order that they don't possibly be placed in jail. The defendant has a right to have a hearing on all those matters within 20 days of the date they enter the plea. The government must prove that those violations of the rules and conditions of probation occurred by preponderance of the evidence. It's a different evidence standard. Usually in a criminal matter, the evidence standard is guilt beyond a reasonable doubt, but for probation violations, it's by preponderance of the evidence. If there is a dispute and they can't work it out, and many times, I want to be clear about this, many times the prosecutor's office, especially with COVID and other things going on, they will get together with the defendant and or the defendant's counsel, and they will really try to figure out what's holding up the probation, and is there a way to resolve it where the defendant can get back on track. And that's important, because with COVID, there could be issues with doing community service. Community service sites could be shut down. There's a delay in getting driver's license now. Some places it's 2 to 3 months. There's a delay in driving testing. There's various different things that have been caused because of COVID that can delay somebody from being able to achieve their and being successful on probation. If there is no workout that can be had, a hearing is conducted. And then if there's proof by preponderance of the evidence of the violation, the defendant is found guilty, and then a judgment and sentence will be rendered by the court on a deferred sentence or continued sentence. If there is a finding of probation violation by preponderance of the evidence in a suspended sentence matter, then the court can revoke the sentence, the suspended portion of the jail term, up to and including the full amount that was envisioned in the plea agreement. That is the basic information concerning our review dockets. Those are conducted at 10:30. And with that, I'm going to allow Judge Hofmeister I would wish for Judge Hofmeister to give us some additional information on that.
I think allow is the best term, because that was one of the best presentations about deferred, continued, and suspended sentences. Judge Mccune teaches CLE occasionally, and I think the professor came out there for a minute. So I'm not going to add anything to that. That was well said.
I don't have any questions. I do want to add something, and certainly I think you'll agree with me. And as a prosecutor and as a judge, I recognize that continued sentences is an agreement between the prosecution and the defense to put someone on probation for a period of time. And if they're successful in that probation, the prosecution agrees usually to allow them to withdraw their plea to the original offense. The prosecutor then asks the court to allow them to amend the charge to a lesser included offense, and then they're allowed to enter a plea to that lesser offense, and then it obviously will go on a record as that lesser offense, and usually there may be a fine that's associated with that. It is incumbent upon the prosecutor to agree to that, and a judge cannot impose a continued sentence. They cannot reduce the charge that is it's something that's it's agreed to, and they don't have the authority to amend the prosecutor's information or the charge that's alleged. The only choice that a judge may have is perhaps to defer it or just do something else that maybe the prosecutor doesn't want to happen. The only other thing that I would point out that in the reduced sentence or the reduced charge, I've had defense attorneys that wanted to have the charge amended to something that honestly was not the offense, and it can't be proven with the evidence that was used for the greater charge. So the typical example would be a driving under the influence charge is the greater charge, and there is a driving while impaired charge, which is a lesser charge. So the bottom line is that when they have a continued sentence and it's to be reduced to a lesser included charge, that means that all of the elements of the lesser charge are met by the evidence that was in the previous case. So I don't know if you'll have any comment on that, but that's maybe too fine a distinction, and who knows, it may be subject to debate. Anything to add, gentlemen?
I think that's a great point, Mr. Bolden, or Judge, is that there are folks who want to come in and we've seen them, I've seen them come in where they want to get a continued sentence and reduce a charge without speaking to the prosecutor. And that's not going to happen. And you're correct on that. That's an important distinction, that we cannot amend charges or grant continued sentences. In my statement early on continues and deferreds, many of the continued sentences we see are a lot of dismissals on costs. But yes, when there's a DUI, assault and battery, and those sort of things, there are many times when those would be a continued sentence can be used to reduce that down to the various lesser offenses. But you're actually correct; it has to be something that would be supported by the facts of the case. So I really appreciate you, Judge, for bringing that up.
And it's incumbent. I mean, you cannot accept a charge that's not supported by the evidence. You can't let them defendant just agree to that. And
True.
Am I still here? My computer just did something. I'm not sure. Can you hear me?
Yes.
Okay. At any rate, the bottom line is there has to be evidence to support the charge that you're accepting the plea to. Otherwise, you're accepting a lie, and you wouldn't do that. So if there's no other comment about that, then let me share my screen one more time. We're starting to run into at least our goal was to finish by 7:30. Let's try this. And so the next topic is the non-jury trial docket and the motion docket, which I believe occurs in the afternoon. So how does that go, that docket go?
Judge Hofmeister, if you want to take that one.
Sure. Well, there's two ways to get your non-jury trial setting. One is to appear at the court records window and simply request the trial. We don't require people to post a bond in any way to have their day in court, so to speak. This court definitely the emphasis is on due process, and the signature on the ticket promising to come to court is bond enough to carry it all the way to the trial setting. The other way is to request a non-jury trial in front of a judge. And those are typically about 3 to 4 weeks out from the arraignment or from the date that they appear in front of a clerk and request the non-jury trial. Non-jury trial just says it's self-explanatory, but it's in front of a judge. Some people refer to it as a bench trial. The city has a burden of proving its case against the defendant beyond a reasonable doubt. The defendant can confront witnesses, can have an attorney present with them, can choose to represent themselves. Our non-jury trials are some can be fairly complicated, but most are no more than a half hour to an hour maximum. At the end of that, if the defendant is found guilty, and the most they would face in a non-jury trial typically are fines and costs. And we advise the defendant of their appeal rights. Again, as Counselor Administrator Bolden pointed out at the very beginning, as a court of record, we let them know that if they intend to appeal, or they'd like to appeal the verdict of guilt, they need to notify both the Court of Criminal Appeals and this court, Municipal Court City of Tulsa, of their intent to appeal within 10 days of the verdict. If they're acquitted, of course, they would owe nothing. Non-jury trials, like I said, are available to anyone that has a fine-only punishment, unless there's an agreed waiver of a jury trial by all parties, the defense, the prosecution, and I believe the judge has to approve that as well. But then you have occasionally have the judges hearing cases that have the potential of jail time. Judge, I'll throw that to you now.
Anything to add, Judge Mccune?
No, excellent job.
I had some major question here I was going to ask about that. I'll think of it here in just a minute. I know what it was. So if I've got a right, I have a right to a jury trial. What invokes that right to a jury trial, and who can waive the right to a jury trial and have a judge trial?
The jury trial right under Oklahoma law is if the fine exceeds $500 and/or there is the potential for a jail term. That invokes your right to a jury trial. You may waive that right to jury trial, as Judge Hofmeister stated, when the plaintiff and the defendant, so the City of Tulsa and the defendant, both waive their right to jury trial. Many folks presume if the defendant waives their right to jury trial, that's an automatic, or that would be an automatic non-jury trial scenario, but that's not quite accurate.
Anything to add, Judge Hofmeister?
No, we do have waivers. We formalized that waiver of a jury trial right because it is a fundamental right in our great Constitution that people are giving up. So we definitely have those signed off before we go and have the hearing itself. Sometimes it's more expedient to have a judge hear a case, especially if it's a complicated matter like a zoning or a code enforcement case, and sometimes both the plaintiff and the defendant will go ahead and agree to it.
Our topic was also motions. I guess this is a motion docket too. Is there anything to elaborate on that? I take that as a no. Then let me share my screen again, and we'll move on to the next topic, and that is jury trials. Well, that's good that we're going to cover this one next. There's a sounding docket. What is that? It's another courtroom slang, maybe, or shorthand. And what should a defendant or what should a judge expect in a jury trial? Don't everybody speak at once.
You want that?
Yes, I'll take it. We have a jury trial. We have jury trial term 4 times a year, and then approximately 3 weeks prior to each jury term, we have a jury trial sounding docket. That is a docket where both the city and the defendant have not been able to work out their case through a plea agreement or any other type of resolution, and each party wants to have their case tried by the jury. We have it at 2 o'clock on Friday afternoons. The defendant will come in with or without, either pro se without an attorney or with their attorney. The city prosecutor will come in the courtroom and will determine whether or not the case is procedurally ready to move forward with a trial. Many times during that, and then we'll set obviously a convenient date in the future for them to have a trial. Many times on that specific docket, we will then, folks will then decide that they do not wish to continue with the jury trial, and we will take plea agreements off that jury trial sounding docket. So cases will either be set 3 weeks out for an actual jury trial, or many times they'll be dismissed by the city, depending upon the circumstances, or there'll be a workout between the city and the defendant or defense counsel. And those are resolved either that day, or they'll set it off for a future date to complete the plea agreement. When we show up on our jury trial date, Ms. Harville has her staff out there. They'll greet the jurors, potential jurors. We have a jury pool room. They'll enter the jury pool room. Ms. Harville and her staff make sure that the jurors are who they say they are, and they'll do a preliminary evaluation as to if they meet the requirements of the law to serve on a jury. And then we conduct a jury trial. It is exactly what you see in any other court conducting jury trials in the state of Oklahoma. There's voir dire, there's opening statements, there is direct and redirect. The city will rest their case, the defendant will have their defense case. They'll rest, sometimes there'll be rebuttal and witnesses are presented, and then there'll be closing arguments, and then the jury will go and render a verdict. Just as like you'll see any other district courtroom in the state of Oklahoma. And that is a kind of a generalization, and I'd hope Judge Hofmeister might fill in some specifics just so we don't have any questions on it. Thanks, sir.
Sure. One of the goals we have is for a one-day jury trial. You know, one case, one day, respecting the time of the jurors that come down here. We could commit as best we can to conclude in a day. Occasionally we've had to have folks come back to hear closing arguments the next morning and then deliberate. We have juries of 6 members compared to, we don't have the large 12 member juries. And Oklahoma's a little unique in that it's still allowed to have a 5 verdict rendered with 5 members of the jury and 1 holdout, and still have either a conviction or acquittal. I've said that right, I hope. But you know, we're unique in that regard in the state of Oklahoma.
I'll throw another question here at you. I've been called for jury duty and I don't show up. What's going to happen, or what could happen? The word body attachment comes to mind, but I don't know if that's the proper terminology these days. But
well, you know, first off, I mean, it's a good question. We do a really good job. I say we, that would be Ms. Harville, does a really good job with her staff to first of all, we do talk and spend a ton of time with folks who may struggle because of health, that may have other issues. Right now, we have many folks that are having to help their elderly parents get through the pandemic and other things. So we have a very robust communication system with potential jurors to find out if they qualify for an exemption, if they qualify to be excused, if we can defer it to a different date so that they can appear. That's really the important thing here is that, you know, we're going to work with you as a citizen. Whether you're a defendant, a potential juror, a witness, what have you, you're a citizen first. That's our philosophy. You're going to get that respect, and we'll help folks, whether or not they're potential jurors, a defendant, or what have you, to give them all the information they need and work with them to satisfy their civic duties.
Yep. Thank you. I think that if I didn't show up, I know that It's very rare that a judge would issue a body attachment, but it's essentially the equivalent of a warrant. And when you receive a jury summons, again, correct me if I'm wrong, you're summoned to court. It's an order of the court to appear as a juror. And if you disobey that, it may not be a crime, but the judge can order a body attachment, have a sheriff or have a police officer serve that order to make that juror appear. As a general rule, you don't want that person on a jury, but at any rate. If there's nothing else on that, then I think we'll go to our next topic, and that, surprisingly enough, is appeals. What happens if I'm wrongly, or I believe I'm wrongly convicted, or the judge made a mistake? What is necessary for an appeal, and how are those processed to the extent that a trial judge knows?
Well,
There's a time limit, is there?
yes, sir. So the catastrophic thing happens to you. You're a defendant or a defense counsel, and you lose a trial. You have 10 days from the time the judgment and sentence is rendered in open court to appeal that matter to the Oklahoma Court of Criminal Appeals. You must file notice of intent to appeal and designation of record within 10 days of the date of the judgment and sentence in open court with the Tulsa Municipal Criminal Court. You must also file a notice of intent to appeal and designation of record at the Oklahoma Court of Criminal Appeals. And then from there, you must abide by the rules and procedures of the Oklahoma Criminal Court. And the filing of the notice of intent to appeal and designation of record is jurisdictional. It is extremely important that is done within 10 days.
Anything to add, Judge?
Yeah, that applies both to verdicts in a bench trial in front of a judge and to the jury trial verdict. And so definitely a short window of time. Always encourage individuals to get legal advice if they've represented themselves. The process can be complicated and costly in some ways. You have to typically buy a transcript, although you can, of the proceeding, although you can also apply for a pauper's affidavit to have a court funded transcript provided if you're determined to be indigent. And it's just a complicated process. So even though we're that far into it, they've represented themselves all the way through, we still encourage folks to get legal advice to help navigate the appellate waters.
In my experience in the municipal court, when I started out, we had to file full-fledged briefs, and then there was a stage in the Court of Criminal Appeals where they had something called an accelerated appeal docket, and it was to a large extent filling out a form, which hopefully satisfied all the legal requirements. And now I believe they've gone back to an appeal now requires full briefing, and they've decided not to do that. Is that the case?
Not sure.
Not your bailiwick, huh? Okay, that's for somebody else.
I believe they still have the accelerated docket, but I believe it's issue specific. There's certain things you can go with an accelerated docket, and there's certain things you cannot. That's my understanding.
Okay. Yeah, it's always an experience to go to the Court of Criminal Appeals. So if there's nothing else, then let me share my screen one more time. And then we have questions and the closing here. So I don't have any questions pending. I do want to ask the judges really to kind of tell me what it's like to be a judge. And by that I mean, I know a little bit of what it's like. I think you shared with what it's like in court. But how does being appointed a municipal court judge affect your life?
I will jump in on that. When you become a judge, and whomever will be selected as the next full-time municipal judge, it is truly a pathway of service, in my opinion, and one in which you have to restrict yourself voluntarily to things that other individuals might find frankly unconstitutional, certain speech, certain organizations that you can't join, certain involvement in political action. It's just prohibited. And I would really encourage everyone in earshot on this and everybody that watches it, if it's supposed to be played in the future, take time to go to OSCN and look at the Code of Judicial Conduct. And it will clear the air as far as what the commitment level is as a judge. And some may actually go, you know, I enjoy my freedom more than that, than the potential of doing it. I'm not sure I want to give up some of those things that I've enjoyed over the years. Now, having said that, it's also one of the most fulfilling jobs I think any human being can have if you approach it with humility, respect, and really enjoying people. I mean, if you don't enjoy people, time to go look at the Court of Criminal Appeals, or not the appeals, but some other area where you have less contact with individuals. It is a day-to-day contact that I frankly love. I know Judge Mccune enjoys that too. It can be exhausting at times, but it's also very, very fulfilling. And the other commitment I'd make is whomever is selected by the City Council, and we really respect their decision process and look forward to seeing who that individual will be. But we will commit to come alongside and help in any way we can make the transition into our courts one that's positive. Judge Mccune has excellent resources to help bring new judges up to speed. We have administrative orders that have been filed and logged and give you the history of the court. And frankly, we would welcome whoever it is with open arms to become part of the court down here, and we'll do everything that we can to support them to be the best judges they can be.
What I would say is just a couple different things. I think it's been one of the most rewarding job. It is the most rewarding job I've ever had. I feel like I had a calling to be a public servant, and I greatly appreciate the opportunity the City Council has given me to continue to do this job. I also am very blessed, I believe, to be working with some of the finest folks in the judicial area, right? Ms. Harville's been doing an incredible job. It's a joy coming in the door because we're treating everybody with respect, whether you're the judge or you're just somebody walking in to watch the court that day, or a witness or a defendant or what have you, or an attorney. You know, you come in and it's a joy to walk in the building. We have great staff now, and I have personally for years. So I enjoy who I work with. I've got a colleague, Judge Hofmeister, who's assisted me with the Judicial Conduct Code, who's helped me embrace the lifestyle of the judge. And he's done an incredible job doing that in his own life. But there are some disadvantages that some people may not like, and Judge Hofmeister talked about it. You don't put the political sign in your yard. You can't be involved in fundraising and charities. There's all these different rules you do, not only because of the Judicial Conduct Code, but because, for example, Ms. Harville, Judge Hofmeister, and myself, we are also representatives of the city of Tulsa. How we conduct our business at this courthouse and at 9:30 at night is important to the city of Tulsa. And it tells citizens what type of leadership they have. Yes, we're the third branch, but the eyes are going to be on you, and how you conduct yourself at work and away from work, day, night, weekends. People are going to be watching. And so how I conduct myself is I'm a representative of the city of Tulsa 24/7. And how I conduct my business is going to have a direct impact and reflect directly on the city of Tulsa. And some folks, it's going to be difficult for that change. But to me, absolutely worth it. Absolutely worth it. Wouldn't give it up. Wouldn't change anything. So, but it is a difficult choice for some. But it's a life-changing experience.
I would like to say that it's important, I think, that anybody who wants this position and that it's a strain. I think it's a strain on you. One of the things that I won't apply to be a full-time judge unless I'm drafted, but no. I think that I know that you all have not had a day off for probably over a year. You're not like civil service commission employees, civil service employees for the city. You're an appointed position. It is not while you're employed, and you're certainly compensated. You don't have a guarantee in 2 years that you're going to have that job again, unless you do a good job, the good job that you've done so far. But I occasionally like a day off, and I know that there are associate judges that are here and that you have that can fill in for you, but it's very difficult to do that. You don't get 2 weeks a month or 2 weeks a year for vacation. I don't believe you get sick time either. I don't know how you work that, but so I think that there is a commitment that you've made and a real personal sacrifice not to have those benefits, and to have those benefits, or at least your job reviewed every 2 years. So I don't think that part would bother me, but the commitment of time to your job is something I think anybody applying for this position that's open in the court needs to consider. Georgina Matul, Tile, I may say her name wrong, has commented here a question, but she said you all did a great job on our court process, and she appreciates the time and planning and presenting this town hall. So thank you, Georgina. And I'm going to check the chat. We, for some reason, didn't disable it. They just say excellent job, and I have to say you all did a very, very good job, and I might need to make sure I don't. Oh, another appreciation from Tina Pina. So thank you very much. I really appreciate you all being here. If there's anything else you want to say before we end this town hall and you get to go home.
Just thank you again. Very grateful for the years of service, and Mr. Bolden, thank you for hosting this. Sherry Harble, thank you for the leadership and the positivity you've brought to this court. And of course, Judge Mccune, thank you for your leadership and your collegial interaction with all the judges. Thank you.
I just want, same thing here. I want to really just appreciate the council allowing us this opportunity. I know Mr. Bolden, who I call Judge, who and his staff have worked very hard. His staff, he's got a wonderful staff, and this has been an incredible approach to how they're doing their job at the council, and his staff's done, and Mr. Bolden and his staff done a wonderful job, put a lot of time into this and other things, dealing with reappointment and appointment of new judges and other things revolving around the court. So once again, appreciate all y'all. As you can tell, folks, I've been very appreciative of Ms. Harble and Judge Hofmeister, because quite frankly, they do a great job and they care. They're public servants who care about their job. They're customer service, community service, public service generated. That's the type of people they are. And so I greatly appreciate them and what they do. I'm also excited, and I want to wish those folks out there that may be applying for this job, this is a great opportunity, and I want to wish you all good luck. I believe the council will make an incredible choice. And we are going to, as Judge Hofmeister said, do everything we can to get you in here whether you get the full-time position, you are possibly a part-time position as an associate judge, or you get reappointed, then we're going to get everybody in here. We're going to work with you to get acclimated and give you all the resources you need to be the best judge you can be. We'll provide you with additional information on where you can do some additional training through the National Judicial College. Ms. Harville has even training for, I was involved in some of Ms. Harville's training today on procedural justice. So we'll get you set up. And, Judge Hofmeister did a wonderful job helping me, and I look forward to passing it on, passing it forward. So good luck to everybody that's applying, and we wish you all well.
Again, I want to thank you, Sherry and Mitch and Jerry, for what I think we pulled it off. And I have a little bit of apprehension about doing this, and I'm surely appreciative of Megan Boyd and Elizabeth Tankard for sitting in here with us and making sure that this comes off well. I know that I want to reiterate our thanks for the service of Judge Shapiro, who is retiring and who will be replaced by one of the great applicants that we have or will have. I would let the potential applicants know that when the applications close on the 23rd at 5 o'clock, that'll shut the door. And the council has a subcommittee that will consider those applications. It is very unfortunate if we have, and I think we will have at least 20 applicants, that we only can select one, or I don't have any say in this, but the council can only select one, and probably very few will get an interview. But the applications are extremely important. That's your initial impression and your hope to go forward to selection. And there will be many good applicants, I know, that will not be selected. There can be only one. So I hope your applications are good. I know that the council will treat it very, for lack of a better term, judiciously, and that they're going to try and quickly review those applications and have interviews scheduled in May. Their hope is to have this decision made by the end of May, so whoever is appointed would at least have 1 month to prepare for assuming office on July 1st. So I don't have anything else other than my greatest appreciation for everybody involved in putting this on, and I hope that the participants gain something from it. Thank you.
Thank you.
With that, I think I will stop the Facebook feed.
All right.